Good afternoon, everyone. Welcome to the second day of our webinar on solitary confinement, unfinished business. We had a really packed and useful day, I thought, yesterday, with some really emotional interjections by some of our panelists. Today, we have, I think, an equally interesting set of speakers for you, and what we hope will be a thought-provoking set of panels. We want to move more today into the areas of what's next. What can we do? As we said yesterday, the solitary confinement policies have changed quite a bit over the last 4 years since we held our last conference, but there's a slow pickup again. More and more jails and prison facilities have begun to use them, particularly since the pandemic. So we want to look today, among the other things we're going to look at, is what alternatives there are. When you have to use solitary, what would be the measures and standards for using solitary, with the idea of eventually perhaps eliminating the practice altogether. Before I do, just some housekeeping. We're going to go today till about 5:30 with our panels. You should all have copies of the agenda and copies of bios of all of our speakers, as well as a list of all your colleagues, all your fellow reporting fellows who are in this conference. One thing I would ask is that if you do stories, we hope you will do some stories either based on what you hear this week or as your projects that you're planning to do as a result of ideas that you get from the conference. If you keep us informed, let us know what you're doing, and obviously send us the links. Perhaps we can cross-post your stories. I will always be glad to do that. But that's essentially important for us to, in order to keep doing this, we have to show our sponsors and funders that this is a really useful exercise. We've done this several times, and it sort of helps your future colleagues be part of the kind of things we do. So if you have any questions about it, obviously, contact me or contact Caddy, but we'll look forward to seeing the great work you're going to be doing as a result of this. Also, I think most of you are aware of the Crime Report, which is our main outlet, our main platform for the work we do in covering criminal justice issues, telling you about new research, displaying the stories that our fellows do. You should all be subscribers to it. Those of you who aren't, I'll be glad to put you on. As fellows, you do get a free trial. It's a cheap subscription anyway, it's pennies per month, but for the first year you get a free trial subscription, and that entitles you to access the entire site, all the resources on the site, and it also gets you access to our daily newsletter, which comes out every day about 12 noon or 12:30 noon. The other thing I wanted to mention to you, also if you don't already know, is that our contest for the best journalism, justice journalism for this year has opened. You can look on our site for details about the applications and how to submit your entries. This is probably the only national prize exclusively allocated or dedicated to criminal justice reporting. And it's one of the more prestigious prizes. We'd like to think the Pulitzer, in a way, of criminal justice reporting. Many of you already know about it, but I just wanted to flag for you that the application process is now open and the submission process is now open. And you can see all the details and how to do it on our website. A last point I wanted to say is that, that if you have questions that aren't answered for our panelists, I will try to send them to our speakers afterwards. I've already got some answers from some of our speakers yesterday, which I'll send to everybody. Today, at the last panel, as we do in many of our other programs, we're going to have kind of a wrap-up, a journalist roundtable, which will give you an opportunity really to talk a little bit about your projects, about your concerns, about covering solitary confinement issues, and in fact, corrections issues in general, which is a really uphill problem, as most of you know, just to get inside prisons and jails to really report intelligently about them. And we have some really interesting folks who are going to be talking during the roundtable about some ideas they have about what you might cover. So be prepared for that. It might go on a bit longer. You're welcome to stay as long as you can and give your ideas. And we'll give you a chance actually to get online, get on screen, and talk about your perspectives on what you've heard during the last 2 days and issues that you've had in covering solitary confinement as well as other correctional issues. So that's my basic housekeeping for today. I want to start with our panel right away. Our first panel, according to our agenda, is going to be another conversation with two of the more distinguished thinkers and practitioners in corrections and solitary confinement in particular, Judith Resnik of the Arthur Liman Center at Yale, and Jessica Sandoval, who is the director of the National Unlock the Box campaign. And the idea here is that each of the speakers will speak for about 10 minutes or so with some initial ideas about where they're coming from, and then we'll engage in a conversation and open it up for Q&A from the rest of you. So I want to start with Jessica first. Her full bio is in the list of speakers that you have. She is a national director of the Unlock the Box campaign to end solitary confinement. She has 25 years experience in reforming youth and adult justice systems. So Jessica, welcome to our platform. It's great to see you and have you there, even if it's just virtual. So the gavel is yours, or the mic is yours.
Great. Thanks, Stephen, for the opportunity to speak, and to all of you who are joining us. I am actually going to share a short PowerPoint presentation, which I typically don't do, but there's so much going on, and I wanted to give everybody a sneak peek of one of our tools. So I'm going to share my screen here, and just open by saying that a lot has changed in the field. I know that over certainly the last 5 years that the Unlock the Box campaign has launched, we're able to really kind of take stock and look back, and also look forward to kind of what is in front of us. We've been having conversations with people on the Hill, which I'll get to in a little bit, but there's legislation that has been introduced since 2012, and we took a look at that legislation and we said, this really needs to be updated. So much has changed, and so we have definitely, I believe, started to really move the dial on really ending the practice across the country. So what I'm going to talk to folks about in my opening comments is just really where we are. We have, let me, wow, that's interesting. It's not skipping to the next slide.
Jessica, do you need some help, or we could ask? We can bring in.
There we go. I guess I have to just I have to go to the screen above me here. Let's see. Let me see.
By the way, we will post the PowerPoints on our site. We have a conference page set up. Both our PowerPoints and any other visuals will be posted on the site for you guys to look at later.
Okay, great. So what I'm going to talk about today is just really where we are in the movement, and I'm trying to make sure that this is, oh my gosh, what is happening? And I'm excited really to share like what's happening at the state level, what's happening at the national level, and to give everybody a sneak peek at this new but not released legislative tracking tool that I think will be really helpful for all of us in the field. And we'll be previewing that today, but also releasing that probably over the next 4 weeks. So here's just kind of an idea of what my points are in my opening remarks will be today. So what you see here in front of you is this map, and this is taken from our new data tool. And it captures the legislation regarding solitary confinement from 2009 until now, really current time. It updates real time every 5 minutes or anytime something's been entered into the database. So what you see here is from 2009 to present, there's been almost 900 pieces of legislation that has been introduced over the course of the last 14 years, which, we hadn't really had this kind of access to this information, but my team has been working really diligently at developing this tool for the field. It's pretty clear where things aren't happening. You see some states here that are white, where there's been no legislation introduced on solitary, and then you have much brighter states like places like New York, where 119 bills have been introduced on solitary, and Florida 46. So you can kind of get an idea, of what is represented and who is represented in this national snapshot. The next slide really is representative of what is happening kind of the trends and this steady path forward that we have here. It really shows that from 2009, we see this trend line continuing to increase in activity. There were 14 pieces of legislation introduced in 2009. And at the height of COVID in 2020, you see that there's almost 150 pieces of legislation that had been introduced. And what this tells us is that we believe that this is an indication that there is really kind of a tipping point here that is imminent towards, ending solitary confinement. And it's very exciting. We're winning in a lot of places, and this obviously is a conversation happening in a lot of legislative buildings and among advocates. So one other piece I thought you all might be interested in is kind of what is trending. This database that we built gives us this information, which is, I think, really great. And so we've been tracking these trends now for a few years. Before, it was very manual operation on paper, then we went to a spreadsheet, and now we're at this point where we have this amazing tool. And this is where kind of the trends currently stand. There's obviously a very concerted effort to end solitary for young people. You see that 40 states have introduced bills. Pregnant people, people with mental illness, disabilities, and medical conditions. There's other trends on here that haven't kind of elevated to these top 5, but certainly people are focusing on the LGBT community in solitary confinement and others. So one trend that we haven't added to this database yet, but one emerging trend that's not represented here is legislation that we're starting to see that creates independent oversight bodies, and that really will investigate complaints and also oversee solitary confinement practices and implementation of bills. So we're really excited that this is emerging, and we'll continue to track and monitor this. But I suspect that we're going to see more and more of this this trend. I wanted to mention what the challenges are to solitary confinement, because there are significant challenges, and one of them being COVID, which kind of an alarming number of people continue to be locked down in solitary, and seems to still be the primary response to the pandemic by correctional administrators. And what we sadly have started to see is our fears that we thought might happen, which is that we really thought that the policy gains that we'd reached over the last 10 years were going to be rolled back because of these lockdowns. And what we're starting to see is a disturbing pattern coming out of corrections, which is many of these COVID policies becoming more permanent policies. And so we will have to make sure that we're, monitoring that, and also, making sure it doesn't continue to threaten our gains anytime in the future because of other public health and threats of civil unrest. Another area that we're really challenged by is corrections. We have seen kind of a lack of moral courage by governors who have watered down otherwise promising proposals or vetoing bills. And it's been really challenging to watch that happen. The good thing, I think, silver lining in this piece is that when the vetoes have happened, mostly by Democratic governors, what we've seen is the advocacy community come out to be even more resolute. And the following year after these vetoes have happened, we've seen these bills actually become law. So there is, some, new history there that challenges this resistance. And as I'm sure we're all watching unfold in several of these states, these correction officers unions coming out in opposition of reform and change. I would say the third challenge really is around data. And I know yesterday I heard this mentioned several times in presentations. Right now, we don't have a mandatory reporting system. And so we really don't often know who is in isolation, for how long, and for what reasons. And it's, I think the practice of solitary confinement is notoriously underreported based on, what people consider solitary confinement and what loopholes exist. We do know, though, with data that it consistently shows stark racial disparities across the country. We also know that it shows, that solitary is harmful, both psychologically and physically, on people. And, we would like to see, more changes to data and more, more transparency. And so that's certainly where our challenges lie in the movement currently. I'll next talk a little bit about the successful strategies that we've seen across the country, and I think in part why we're really winning. Certainly, there's incredible work being done across the states, having a profound impact. And many of these campaigns are led by survivors of solitary who are leading legislative efforts to curb solitary confinement and ultimately advocating for the end of torture. We've seen, like I mentioned earlier, these kind of, trends upward, just that there are more and more people who are looking at ending prolonged solitary confinement by establishing the standard of 15 days or less, that they're really focused on getting vulnerable populations out of solitary. And we're seeing a lot of success with that, including in a lot of these bills that people are ensuring that there is data collection and reporting that's happening as part of these legislative fights. And, again, like I mentioned, this kind of new and emerging trend is just another tool that we can be using around creating these oversight, independent and citizen oversight boards being written into legislation. I think there's one really interesting piece to note that since 2019, there's been 3 campaigns that have really implemented the Mandela rules. New York State with the HALT bill, Connecticut, and New Jersey. And as part of those campaigns, each of them were successful at also closing a prison. And so I think those are really interesting strategies that we're seeing happen. We expect that there will likely be somewhere in the realm of, a dozen or so states that actually will be introducing Mandela type bills that look at HALT and some of these other states, Connecticut, coming out in the new year. And so we're really excited to see where that goes. I don't know how many of you are following what's happening right now in California, but certainly there's a lot happening in California right now, New York, here in DC. California, the governor has a Mandela bill on his desk right now that has to be signed or vetoed, or I guess he can do nothing by tomorrow. So we're all pretty anxious about the outcome of that, because we know it will be a game changer and really moves the path forward, I think, across the country. So it's a really important piece to be watching. New York City, they had a very tumultuous hearing yesterday on the bill that would end solitary confinement in jails, city jails in New York City. And that bill will be going up for a vote soon. So we're really keeping a close eye on that, monitoring and, talking with our friends on the ground there. And then DC also introduced a solitary bill that would end solitary for the DC jail. And that's coming up for a hearing this month. So there's a lot happening just in this last part of the year, which is pretty unusual, but really important pieces. So that's what's happening around the country. I think one last thing I want to note is what's happening at the federal level, because I think it's really important to know that, for 4 years under the Trump administration, we really didn't do anything because there wasn't a whole lot to be doing. So we just a little over a year ago, several of us, national organizations, created and formed a task force, really in response to President Biden and Vice President Harris's campaign promises to end solitary confinement. And we thought to ourselves, well, that's a big goal. They probably need a little help. So let's create a blueprint for them in which they can follow to really look at how to end solitary at the federal level. And that blueprint has been helpful in the many conversations we've had with the White House, with the Department of Justice, several legislative offices. I think we're making pretty significant inroads on the federal piece. Representative David Trone just introduced a solitary confinement study bill, which we hope will, get us to where we want to be on the mandated data reporting from the DOCs across the country. It will also provide money for states, incentive money for states to move away from solitary. So there's some really exciting things happening, and we hope that in the new Congress, we'll see even more legislation and movement from the White House. So I will stop there, and I will put my contact information up just in case anybody wants to jot that down. I'm sure it's available in the program as well, but and I will stop this share.
So thank you, Jessica. That was an excellent wrap up. Lots of food for thought. We will put up the obviously your contact info and the full PowerPoint on our website after the conference is over. But I want to move directly to Professor Resnik. Along with Jessica, Professor Resnik is probably the reigning national expert right now on and commentator provocateur, I guess, of the solitary confinement issue. She has just finished her 5th report on administrative segregation. She is the Arthur Liman Professor of Law at Yale Law School and the founding director of the Arthur Liman Center for Public Interest Law. She has a forthcoming book called Impermissible Punishments, in which she explores how incarcerated individuals are reconceiving the boundaries of state punishment, which is really well said, I think. And I want to remind you that if you have questions, please put them in the Q&A window, and we will get to them after our conversation with our two speakers. So, Judith, the floor is yours.
Thank you. And I know I have a PowerPoint that Christopher is going to help put on the screen. So this is the moment for it. Thank you for starting. And so I thought, first of all, I'm delighted to participate, and Jessica, love to always listen to the remarkable impact that you are having, and glad that John Jay is convening again. I thought it would be most helpful for me to give you a snapshot of what work US constitutional law does and does not do in this space, intersecting with the data that we have collected from the people who run prison systems and tell us what they decide to tell us about their use of solitary confinement. So if you get to the next slide, which is, we were moving slides, my computer was cranky, and so here we go. We're all heirs to the Enlightenment, which is to say that Jeremy Bentham and Cesar Beccaria and some others pushed to say that punishment should be useful and purposeful. And you can see the footprints of this 19th century Enlightenment rationality arguments in the law. So US constitutional law says you're supposed to have something called the penological justification. When you go and ask what those are, and I just flag some: incapacitation, retribution, deterrence, rehabilitation, institutional safety, cost reduction. First of all, a big capacious list. Second of all, in tension with each other. And third of all, totally missing is 20th century egalitarian movements where incarcerated people said, hello, we're people. We have dignity. We have rights to limit how the state can punish us. We're not saying you can't punish us, but we're saying not like this. And a democratic social order, these remarkable individuals persuaded judges, sometimes who appointed lawyers for them, to limit the use of certain punishments. And my one pathetically powerful example in US history is the 1960s, Arkansas whipped people, saying that was a useful mechanism for discipline. And the federal district court judges said, yes, as long as you do it not arbitrarily. And then finally, Judge Harry Blackman, then on the Court of Appeals of the 8th Circuit, said, sorry, impermissible. So of course the question is, what's impermissible here? If you turn the next page, you'll see that because of the energy of these people intersecting with the political and social movements, with NGOs, with the ACLU, the NAACP Inc. Fund, with law school clinical programs and others, help to push case law that asked the US Supreme Court to say, hey, you can't punish like this. Now, the old cases from the late 1800s and early 1900s involve US Weems's about shackles in the Philippines. And the court starts saying, wait a second, not excessive, not unusual. The big breakthrough in 1958 is a plurality opinion by then Chief Justice Earl Warren, saying it has to comport with evolving standards of decency, marking the progress of a maturing society. Impossible to live in 2022 as we do without dropping the footnote that current members of the Supreme Court have not embraced evolving standards of decency as their analytic tool. But notice that when we get to the death cases in the next Furman cases, we're looking at the idea that it not be arbitrary or discriminatory, which is a way to say race, and the role of disproportionate and animus in the criminal legal system in the United States. If you turn the page again, by 1976, there's a case. Texas had one doctor for 17,000 people, and James Gamble was injured. And in an opinion by Thurgood Marshall, the first Black man to join the United States Supreme Court as a sitting justice, deliberate indifference to serious medical needs of prisoners constitutes the unnecessary and unwanted infliction of pain. For all of us who were involved in COVID litigation over the last 2 or 3 years, embraced this with with great success at the lower court levels and then not success at the US Supreme Court level. But this idea that there's nothing logical about deliberately harming someone, and this idea of logic. It's not all the way, but for US law, this is an affirmative obligation to provide health care more than existed before. And then in 2019, in a case about excessive fines, you have this concept borrowed from England, this is the originalists among us, that talks about the idea that this government shouldn't set out to ruin a criminal. And of course, I want to ride the banner of ruin. Clearly, the idea that you're not supposed to let people be ill, this idea of ruin, it's said by Justice Thomas in the context of economic destruction. Obviously, there's a big question, what does that mean? Because it should end a lot of the terrible fines and fees practices. But the concept that you shouldn't ruin people is one that needs to be much more broadly engaged than has currently been in law and practice. But of course, it's at the core of the concern about solitary confinement, because ruin people is there at the core. Turning the page, as I'm giving you a little snippet of the governing legal doctrine, it comes with a great watch out. So this is a really important case. It started with a wonderful name, Caleb Washington versus Frank Lee, that is a prisoner in Alabama against the director of Alabama's system, but of course it's echoing George Washington and Robert E. Lee in the choosing of the name. And in the choice of this, the US Supreme Court affirms a decision. Alabama had a statute, de jure, do not chain together Black and white people. The lower court said unconstitutional. At the Supreme Court, they agreed, but 3 justices wrote words that haunt all discussions of the law and the practice of prisons in the United States and elsewhere. Prison authorities have the right, acting in good faith and particularized circumstances, to take into account race in maintaining security, discipline, and good order in prisons and jails. And that idea that security justifies limiting or not respecting constitutional rights in this context against race segregation is one that doesn't just lurk, but is central to understanding US law in the current situation. Now move to solitary confinement in the Supreme Court to the next slide. And in the next slide, you hear Justice Anthony Kennedy writing for a unanimous court in 2005. And first of all, he provides a description that journalists should iterate again and again, because it's one way to capture the absolute grotesque situation of solitary confinement. This is Ohio, 2005, 7/14, 23 hours a day, a light on all the time. People are deprived of almost all environmental and sensory stimuli, of almost all human contact, indefinite. Now, one might think the answer was absolutely not. This is the equivalent of whipping or worse, and you absolutely can't do it. But turning the page, and therefore to the next slide, instead we see this unanimous court talking about institution imperiled by gangs, organized, fueled, race-based, fear, violence, harsh. It might be an only option. Now, this is a terrible set of sentences to be iterated by anybody, including in the US Supreme Court. The Justice Kennedy himself walked back from this in 2015 in a concurrence, but what this opinion does do, by turning the next page, is it does say Ohio's version is so awful that under the US constitutional current limited understanding of the liberty interests of incarcerated people, due process is triggered if you can show that what's happening to you is atypical and significant hardship in terms of ordinary incidents of prison life. So watch law take for granted the thing called prison and make it to be true. And here Justice Kennedy says, given that solitary in Ohio could be indefinite duration and totally wiped you out for parole and the like. It is together atypical, and therefore you get the potential for a hearing. You get a hearing in Ohio and other cases challenging this. And I can, in an article I wrote called Punishment in Prison, with a bunch of talented younger colleague students, hundreds of thousands of cases try to decide what's typical and atypical. Most of what's typical is nauseating in its typicality, but I'm about to show you that in fact, the use of isolation is, as Jessica has and many others have documented, all too typical. So if we turn the page again, we now get to little windows into the use of isolation in US prisons. So the first proposition is there's an organization that was called the Association of State Correctional Administrators and is now called Correctional Leaders Association, that we in the Liman Center began working with in 2012 to try to understand something about lots of prison rules, of which visiting is one, administrative segregation another, and then much more generally, how much time people spend in cells. The current nomenclature in corrections of an umbrella is called restrictive housing, which is ADSEG. I mean, there are hundreds of words, but basically the shoe, solitary, punitive, disciplinary, pick your word. And the goal was to try to understand from the perspective of the people running systems. One of it was to try to help them count and remind them that they needed to count who was in for how many hours, and then to report about it voluntarily in addition to legislation that developed. And so we have these series of reports. And the next slide tells you that we developed an umbrella definition relying on Mandela of saying 22 hours or more on average, 15 continuous days or more. And most recently, we had 170 questions that went out that the correction leaders distribute to themselves to tell us from their own data. So every scrap of information, or almost every scrap, comes from the self-reports of the people doing this. And the next page tells you that there is this huge question to be asked, properly by Jessica and many others. Why 24 hours? Why not 17 or 10 or 5 or 1? Of course, the hope is that there's no way to define it because solitary stops. And for right now, a way station is to have people account for the people who they're putting in isolation on the way to getting there to be none of it, that isolating people, albeit maybe briefly for safety for 2 seconds or 45 minutes, but maybe you're never isolating people, isolating. Maybe it's restraining people somehow or the like. But this time in cell is a really important question of what does solitary mean. If you go then to the next slide, you'll see that this is the cover of a book. I believe your website has it's a PDF you can download free of charge, of course. In addition, if you want hard copies, we're happy to mail it. Turning the page, I'll tell you that in the report we just released a month ago that involves data from the July of 21, you have 36 jurisdictions reporting. And if you turn the next page, because I'm going to whip through, just going to give you a flavor of what you can find if you have the patience to read the FAT report. Basically, we can tell you about basically 61% of US population in prison at the time, which was then 1.2 million people. So we got reports on more than 730,000 of these people. And of that 731,202, 3.4%, or about 25,000, were reported by their settings to be in solitary, not independently verified, not checking their webs, just what you're telling us, counting them and adding them together. If we extrapolate from that number, we're guessing that somewhere between 40 and 50,000 roughly of people would be reported to be in solitary. And if you turn the next page, you'll see that what we do is of the jurisdictions that report, the high was close to 15% and the low was none. And
Judith, one question for clarification. Does this figure include jails, state prisons, and federal?
No. This is the great question, welcoming all and any for clarification. The way the systems work is that in the United States, there are about 4 to 6 states that have what they call uniform, where jails would be included. But almost most of the places, jails are local and or county or parish. And so these are only by request to state DOCs, Department of Corrections, to tell us about people. And more than that, we're actually interested in the people who are in their custody and direct control, because we're asking how many of the people who you house are put in isolation. So whether it's Hawaii or Utah or many of these places out and California or Louisiana, where many of their post-conviction incarcerated people are held in jails they don't control, we say you only can tell us about the people you control, because that's the control on the data to get some grip on it. So this is prison populations and incarcerated 1.2 million people. And a prison population, then it's self-reported. And on top of this, maybe there's some jurisdiction that has 22%, but of the jurisdictions that responded to us, the peak was 15%. If you turn the page again, in terms of duration of confinement, in this subset, not all jurisdictions, we know that at least 2,500 people were in for 3 years or more. We know of many people, of almost 4,000 who are in for 1 to 3 years. So in terms of duration, we're trying to get a grip. And when we first started asking in 2014, what we learned is some people said we didn't count. So we can't tell you. And then sometimes the number was nobody's in for more than 6 years, and that's as long back as they had been counting. So part of this exercise is to say to people running systems before there was legislation saying it, you got to figure out what you're doing to people and keep track of it. Turning the page again, just very quickly to give you a flavor of the data. Of course, we do it by self-identified gender, and you see that it's used more in men's prisons than women's prisons. If you turn the page again, you'll see that there's report at the time that there weren't pregnant people for whom it was used, and that there were transgender people for whom it was used, although the guidelines tell people not to use identity in many places. You turn the page again, you'll see that, of course, we ask about race and ethnicity, and I'll ask you to turn one more time, because the hugest disparate impact at the moment reported, not known for sure, but reported is that Black women, whoops, go back one page, Black women are much more in isolation. Prisons don't use it for women much, but Black women bear the brunt of the use in women's prisons. Now to the next page, serious mental illness. There is no national definition that all the systems use. So there are 30 definitions of it. And we have data that tells you that thousands of people who the system describes as mentally ill are nonetheless in isolation. If we move to staffing, you'll see that on staffing, you'll find that there's just a handful of a dozen jurisdictions that say we do something different to staff this very terrible setting. Some people have special training in mental health, some in de-escalation and like, but not a lot around it. If you turn the next page, and now we're looking comparatively. So we did this for a decade. Doing it for a decade, when we first started in 2014, the best estimate was 80 to 100,000 people were so confined. If you look over time, it goes down to the 60s, 70s, and now we're down a bit. This is self-reported. And the good news is that people who run systems want to describe themselves as having fewer people in. The bad news may be they have more people in than they say they do. But when I first began working in this area, there were many who said this is a really good response. And now solitary confinement has come to be understood as a badder thing to do than it was a decade ago. And credit to Jessica and all the Stop Solitary efforts and all the political and social movements and the incarcerated people's hunger strikes in reframing this. If you move to the next slide, you'll see that when we first started, it looked like we were at 4.6% of the housing population was in solitary. Now we're thinking it's quote down, but don't think down means none. And now I just want to turn the page and flag. Jess has already given you a rich account. When we first started, there was basically no legislation, and our reports did not talk in 2014 about the legislation, as her wonderful trend line shows you. By 2018, 2020, when we were looking at the enacted, moving beyond the introduced to a thicker state, we had 15 states having some provisions enacted, and you can turn again to the next slide to say, we did a clustering that we're up to more and more states with more introduced the next. And here I want to raise a question for you who are reporters by the next slide. You'll see that we use the word subpopulations. I don't want to use the word vulnerable because I'm vulnerable. Every human being, I believe, is vulnerable to being in restrictive housing and becoming ill. And so I think there's a risk that calling it vulnerable populations acts like some people aren't when we're all vulnerable, but there are subpopulations, youth, pregnancy, serious disability, other kinds. And there's clearly legislation that you've heard about. If we move again, there's also this reporting, and I want to encourage the reporters in the audience, go read those reports. One is it's jaw drop what people can get into taking an extra piece of fruit can land you in solitary confinement. Being at risk of security as assessed by an individual is very easy to get in, not so easy to get out. So there are reports that should be read and analyzed. And then the next is, the news is that next slide, please, there are jurisdictions that say we don't use it anymore. I can't warranty that they don't use it anymore, but they say nobody's in for 15 days or more, 22 hours on average or more at all. 10 told us this last time, no people in women's facilities there, and 4 said we're basically out of this business. And so that is a change. And my last slide is to show you, this is again, Justice Kennedy, in an opinion from 2011, he attached pictures. This is California's prisons, and this is hyperdensity. So incarceration lives in this bizarre bifold that is hyperdensity mixed with profound isolation. And of course, hyperdensity is a huge driver of profound isolation. And the cages at the bottom are pictures of people supposedly waiting for healthcare, mental health care, and caged there. And so what this is a very sad picture of incarceration in the United States, but also the unwinding of solitary confinement is deeply intersected with needing to lower the use of incarceration, because incarceration is and density in incarceration is the driver of solitary.
So that gives
that's
me
the way to end. That's the end of this PowerPoint. And
thank you, Judith. That's inspiring. That gives me a good segue to talk a little bit about get both of you involved in a conversation about. We have another 20 minutes or so. We have some questions from the audience, but one of the takeaways that I got from yesterday is that, well, 2 takeaways. One is that changing or ending or eliminating solitary confinement is complicated by the problem of COVID and the problem of staff shortages. And the other main takeaway is that the likelihood of making real serious change in the use of solitary confinement is really tied up with whether or not we can change the general prison conditions as well, what someone called yesterday the prison culture.
Can I just push back on the COVID point for a minute? Because I was very
Sure.
involved in COVID litigation. I mean, one of the concerns about COVID is that people were not kept in distancing of 6 feet or more.
Right.
I think
So let me
that
give you,
the
I'll let you
COVID
respond to that.
There are 2 levels of COVID. One is medical limitations and distancing isn't the same as solitary confinement by any stretch of the imagination. And the second was there was too little distancing in prisons all over the United States. And COVID is not the reason why there's isolation in prison. So I just
Right.
need to sort that. Plus people who are still at risk of COVID, because COVID risk isn't gone, are in much more need of better ventilation, mask, soap, vaccination, distancing, and the same for the staff than currently exists. So I just think we need to disentangle solitary and COVID.
Good point. So, but let me go back to the other point, which is that how dependent real change is on whether we can actually change prison culture, which is something that several people said yesterday. And, Jessica, you talked about a tipping point, which we've reached, but you also acknowledged that things were harder now or more uphill now than they were, say, 3 or 4 years ago. So I'm wondering, let's start with you, Jessica, but whether you feel that much more progress can be made without an understanding, without real change in the approach that we take now to punishment in general.
Thanks. I I just came back from Norway, so I have a different kind of perspective having just been there. But I didn't want to give the impression that it's harder now. I think the fears that these COVID type restrictions and policies would become more permanent and make these efforts harder. And we're starting to see that, but I don't necessarily feel like the legislative efforts are harder because of that. I think that these legislative efforts and the people leading these campaigns are what's going to put pressure on systems to change. It's we're trying to cede some power here, and I think what we're starting to see is some backlash of doing that.
Exactly.
And I certainly think that the prison culture really needs to take a turn and move away from the punishment paradigm that it is. And certainly there are plenty of tools out there to do that. It's a matter of political will, I believe. And we're, putting a lot of pressure on states to have to do this, to really make an effort to start looking at their policies and looking to change.
So there's a sense really that reform in all aspects of the justice system is now put back on the back burner for a lot of reasons. We have a much more polarized society now, and certainly the rise in crime rates, or the surge in violent crime, which is debatable whether it's actually a serious and genuine surge, has made people think less about changing conditions inside carceral institutions than about going back to old type or traditional approaches to public safety. The hardline traditional approach, and we see that in moderates as well as what we might call conservatives or right wing folks. So I'm just wondering, the way both of you look at it, whether that really has put a stop to serious discussion about ending solitary confinement, much less reducing it, taking into account all the different legislative measures that are out there to try to change it. So which is going to win over as we approach this really difficult political period?
So, obviously November matters, but beyond belief. But the other part is, again, to disentangle, the same way that I didn't want to say, don't conflate COVID and solitary, don't conflate aggression and criminal law enforcement with the use of solitary confinement. When Arkansas said we had to whip, they said we had to whip. That's how you discipline people. Well, Arkansas said we had to feed people grue, G-R-U-E, a mush, because that's what we feed people in solitary confinement. There are federal statutes and state statutes that said people are sentenced to bread and water. And over time, people said, I'm sorry, you can't starve people, or you're not supposed to set out to starve people, and you're not supposed to set out to whip people. So the idea that there's a form of punishment that solitary confinement is radical. It's just weird that it's not understood as radical. To limit human beings' physical movement, eyesight, distance, that's Albert Woodfox's insight. It's a bizarre thing to do.
So is putting people in the stocks.
Yeah. So the idea is, it is intertwined and it's complicated because we all know that prisons get lockdowns and there's long-term confinements and there's all sorts of ways in which solitary looks like other forms of incarceration. True, I'd say so too. But it's also different. And you just have to say no. And the idea that you think you're doing something okay by putting people in an incredibly intense relationship with their staff, with the guards, with the people who staff it. The thing that seemed missing in many discussions of solitary is how physically, viscerally oppressive and engaged it is. Every need is outside that door. And there was, when I was listening, we were part of hearings in Pennsylvania on a potential statute, and a person who'd been incarcerated, who's now, from when he was in the Army, talked about how he still eats super quickly because the tray is shoved in and it could be shoved away in 5 minutes. So what's missing from some people's appreciation, I'm sure none of the people in the audience here, is how materially physical it is, in a way that we, social order says, if you can't whip them, you should say the same thing part of it's disgustingly interpersonally enslaving. Well, so is solitary confinement. So I think that should just get off the table.
So there's an interesting question from Clark Merrifield, directed to Jessica, and maybe Judith, you want to weigh in on this afterwards. Clark asked that, the challenges that you mentioned, Jessica, is there a single challenge that if it were addressed, we could expect to see solitary significantly reduced?
Yeah, I think it's setting a standard. The US doesn't have a standard on solitary confinement, and we believe that the Nelson Mandela rules really brings us into some kind of standard or, compliance with, the United Nations. And I think it's important because what we're starting to see is a lot more acceptance of the Mandela rules. I think people agree that 15 days in solitary is too long, but creating a standard in which we can work from to continue to reduce solitary and to end solitary completely. I think, one thing we've certainly seen is, as Judith mentioned in her subpopulations, much of the legislation, targeted at those subpopulations it bans solitary for those populations of people. And that's a lot of people. So I think, if we continue to see legislation getting at, that kind of core and setting a standard, I think what we're seeing now is certainly to become more and more normalized.
Before you respond, Judith, one of the interesting suggestions yesterday from Zoe Taylor from Kentucky's Right on Crime office was that we should take the issue completely out of the legislative field completely and make it an administrative issue. So you have prison authorities and jurisdictions decide, the hours and the limitations. If you use solitary, this is how you should use it. These are the guidelines that you should have. It doesn't satisfy the moral argument, the ethical argument that Judith implied, but at least it gets us off this back and forth debate right now about being soft on crime or hard on crime.
But so there are many people who run prison systems who have done some of that. These are not either ors for 8 seconds. There are North Dakota, some
Colorado.
Colorado. There are many states, Delaware, that have, New Jersey. There are states that have done it. There's nothing inconsistent with having legislative limitations and executive decisions to either end or limit solitary confinement. And I want to circle back, I think, and one of the reasons, of course, to join with people who run prison systems, of course, the challenge coming to Jessica's quite clear list is it's many people at the CEO level of prison administration see this as a problem that they don't want. And they're interacting with staff that live under terrible conditions. And so one of the ways to change solitary confinement is to help the people who staff prisons realize that in addition to it grievously harmful to the people who are inside, it's a really bad task to have, job to have, that is viscerally, physically terrible. So there's a project, I don't know whether you went, Jessica, to Norway with Bree Williams, but the project of the University of California, San Francisco, is to help staff understand, it's called Amend, and it's to help understand that incarceration is bad for the incarcerators, as well as the incarceratees, if you will. And therefore, what you need to do is help the people who are the unions who see this as safety, realize it's not their safety, that their safety's at stake too. And it's their physical well-being, stress and the like, but also it's not a way safe. It doesn't make prisons safer. It makes people ill. And
So
can I just
yes,
interject
absolutely.
one quick thing, Stephen, is that the reference that you're making to this,
Administrative.
No, just about how we're seeing criminal justice play out in these other spaces around, tough and soft on crime, et cetera. That just hasn't really materialized in the solitary space much. I think the same kinds of opposition that we have now, we've historically had. I don't think it's better. I don't think it's different necessarily, but this fighting it out about, tough on crime isn't really showing up in our space the way it is in other criminal justice reform legislation. So, it's been interesting to watch, because we were wondering if that would affect anything in the States. And, what you see is this kind of consistent line, moving forward, and not a lot of drop off.
That's an important point to make.
Yeah.
Well made. One last point raised by Tom McMorrow, and this is a segue from the point you just raised, Jessica, is that he's wondering whether, based on what you were saying, he's interpreting the Supreme Court's decision-making process as being actually quite tolerant of what many of us might consider otherwise harsh treatment of the incarcerated. Is he reading you correctly on that?
So this U.S. Supreme Court, I mean, I think it's not by accident that Jessica and I have talked a lot about both executive action, get the feds to change, get state heads of corrections to change, and legislation. And that's because the current United States Supreme Court is not a hospitable place for many kinds of rights claimants, including people who are incarcerated, both in terms of class actions, just I teach procedure and litigation and the like, as well as in terms of the substantive law of the Eighth Amendment. And so the complicated space of the case I pointed out in 2005 is once the Supreme Court said there's a chance that there's a form of solitary that is so grotesque that you get some procedural protection, it actually helped a lot of people litigate, and it intersected with Jessica's wonderful organizing and so much else to make for high profile public access to figuring out something. Because if you read those hundreds of cases, you hear about people in terrible straits in isolation. But is it that the courts are going to end this? Yes, there is a Fourth Circuit decision then Porter v. Clark in 2018 that says you are making these people physically ill. Deliberate indifference to known medical needs violates the Eighth Amendment. Stop it. So there's a bit of litigation, but the big comprehensive reform has got to come from the people who run prisons saying we're stopping, intersecting with the people who authorize those prisons, which are legislatures saying stop.
Okay, that's a good note to end on. We have to leave it there, but if any of you
One
Yes.
point where Jessica mentioned she's about to have a fabulous website. We're having a new website called Seeing Solitary, which is trying to take, we have so many of these very thick, dense, impossible to use books, and we're making within a total month, there'll be a web portal through the Liman Center and otherwise that lets you use our data more than you can currently use it, but you have to do it by hand.
That would be extremely helpful. If you can send us the link when it's available, and
Yes.
it goes for you too, Jessica, I think that will help the journalists cover more in depth some of the things you're talking about. But I want to thank you both for a really exciting and provocative and knowledgeable presentation. I think it really will help us further, particularly for the rest of today. So I hope you'll stay with us for the rest of the sessions if you can. But we'll take a 10-minute break now before we get on to our next panel. Thank you both.